My name is Jim Turk, and I'm the director of the Center for Free Expression at Ryerson University. I would like to begin today's session by acknowledging that the land on which I am speaking to you today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties signed by multiple Mississaugas and Chippewa bands. On behalf of the Center for Free Expression and today's event co-sponsors, which are the Canadian Civil Liberties Association, the Edmonton Public Library, the Toronto Public Library, and the Vancouver Public Library, I want to welcome you to the Center for Free Expression's virtual forum series panel on protecting privacy in the digital age. New federal legislation, Bill C-11, which is titled the Digital Charter Implementation Act, promises, quote, to protect the personal information of individuals while recognizing the need of organizations to collect, use, or disclose personal information in the course of commercial activities. What's the proper balance between our individual rights and corporate interests? Has the government gotten this right? Our panel will explore this issue in conversation with each other and then with you. I'd like to begin by introducing the panelists to you. The first is David Hutton. David is an author, former management consultant, one of the leading experts on whistleblowing protection in Canada, and a senior fellow of the Center for Free Expression. During his earlier career, he served as a senior executive in industry, led a successful consulting practice, serving an international clientele for 20 years, and wrote 2 authoritative books on quality management that have been translated, published, and distributed on 4 continents. Welcome, David.
Good to be here, Jim.
Our second panelist is Mariette Pilan. Mariette is a lawyer and a member of the Quebec Bar, who throughout her career has represented employees and unions, both in private practice and as in-house legal counsel. Through her litigation work and her participation as a lecturer in union education workshops, she has been involved in debates concerning privacy rights in the workplace, surveillance, collection of data by providers of services, use of wearable devices, the role of data brokers, and monetization of employee data. She is currently working on issues related to the impact of digital technologies in the workplace, the collection of various types of data through sensors and wearable devices, and the use of collected data by different parties. Welcome, Mariette.
Thank you.
Our third panelist is Teresa Scassa. Teresa is a Canada Research Chair in Information Law in the Faculty of Law Common Law section of the University of Ottawa. She is co-founder of the Canadian Journal of Law and Technology, which she co-edited for 7 years. Teresa is cross-appointed to the University of Ottawa's School of Information Studies. She has served as a member of the External Advisory Committee to the Privacy Commissioner of Canada, and currently is a member of the Canadian Government Advisory Panel on Open Government, and is a member of the Board of Directors of the Canadian Information Technology Law Association. Welcome, Teresa.
Thank you.
And our moderator today is Brenda Mcphail. Brenda is Director of the Canadian Civil Liberties Association's Privacy, Surveillance, and Technology Project. She guides CCLA's interventions in key court cases that raise privacy issues, including 2 recent Supreme Court cases which confirm privacy rights in electronic communications. Her research focuses on the social implications of technology, and her recent work has examined the surveillance of dissent, government information sharing, digital surveillance, video surveillance, and the rights issues raised by artificial intelligence. Now, the format for today's panel is that they're going to have a conversation amongst themselves around these issues that Brenda will moderate. And then after 45 to 50 to 55 minutes, somewhere in there, Brenda's going to turn to the audience to bring you into the conversation so you can ask questions of the panelists and they can discuss the issues of concern to you. To do that, we'd ask you to look down at the bottom of your screen and you'll see a Q&A button, not the chat, but the Q&A button. So if you think of a question you'd like to ask the panel, you simply click on that Q&A button and write out your question. And I'd encourage you to do that whenever a question comes to mind. It could be early in the conversation or whatever. Don't hold it till the end. You can just write it there anytime. And then when the panel is ready to turn to the audience, Brenda will ask Ange Holmes, who's the coordinator of our center and is monitoring the Q&A questions, to ask the first question that comes forward. At this point, I'd like to turn it all over to you. I look forward to your conversation.
Thank you, Jim. I echo your welcome to our audience and your thanks to our panelists today. This is a conversation I've been looking forward to. Our panel, as Jim said, is called Protecting Privacy in the Digital Age. And I believe it's a topic that's gaining increasing urgency. It's probably increasingly top of mind for many of us as we come up to almost a year of living in pandemic precautions that have driven much of our daily lives online through technologically mediated forms of communication, like this one where we're gathering today. Some of us are privileged to be able to work at home. We're all encouraged, and at this moment in Ontario, required to do almost all of our socializing, our shopping, our transacting, our learning, in other words, living our daily lives online. And in part, possibly because of that change in our lives, our political leaders are awakening to the concern that data protection and privacy protection increasingly matters at a time when life is lived online. So we have new legislation on the table federally called Bill C-11, or the Consumer Privacy Protection Act, or CPPA, which is an abbreviation you might hear our panelists use over the course of the next hour, which is meant to govern the private sector or commercial sector use of data. We also, ongoing in a separate topic, or a separate privacy law for the public sector called the Privacy Act. And there's a big consultation going on. You have until Valentine's Day, February 14th, to weigh in on that one. So it's a time when there's a moment, a policy window, a moment for change in privacy law. At the same time, our perpetual immersion in these online environments runs the risk of dulling our attention to what's happening behind the screen when we're just focused on making the darn thing work, getting the things done. So there's also a risk that we might acculturate to the technology as it is, rather than hold out hope for technology and regulation to guide it that actually reflects the way we'd like it to be. So we're going to talk today about the new law that's on the table. But we also have agreed as a panel that it's important to frame that new law and the conversation we're going to have about it with the big why question. So the big why question, and I'm turning to Teresa Scassa to ask it, is why does privacy even matter in the digital age?
Thank you, Brenda. And I think that it matters even more in the digital age for many of the reasons that you've alluded to or straight out said in your opening remarks, because so much more of what we do takes place in the digital context, and because that's a context in which personal information is so easily and rapaciously collected, it matters more than ever. The old paradigm of privacy protection and even data protection was one that was organized around the individual and around protecting the individual from unwanted intrusion, protecting the individual against things like identity theft. And so and I think people still kind of approached it as is about me and protecting my personal data. But I think that while that still remains an important piece of the puzzle, we also have to be increasingly aware of the fact that data is used in so many other ways. It can be used to manipulate people's ideas and opinions, and we've certainly seen that with some of the debates and discussions that have gone on around social media, particularly in the context of the United States elections, and we've also seen it with respect to other forms of misinformation and the targeting of individuals and the profiling of them, and then creating these echo chambers. And so it's used in complicated ways to influence what information people receive, how they think, to shape their ideas and thoughts. And that's incredibly dangerous. And it implicates more than just privacy. That implicates freedom of expression and freedom of association. We've seen it, I've just mentioned the election context, where, again, it affects more than just individuals. It can affect a whole society and democratic institutions. And we're also seeing increasingly in the context of big data analytics and artificial intelligence, these concerns that data can be used to profile individuals, to target individuals, and to make decisions about individuals in ways that may discriminate against them, limit their opportunities, limit the choices that are available to them. And all of those things are a matter of real concern. So I think that for so many reasons today, we need to be concerned about data protection. And it's no longer enough to just say, well, I've got nothing to hide. And if I've got nothing to hide, it doesn't matter, because these are issues that affect not just specific individuals, but all of us as part of a community.
Do either of our other panelists have anything to add to that before we dive into our discussion of the new law that's on the table? Seeing nobody jumping up and down, I'm going to just describe very briefly Bill C-11, which is, as I mentioned in the intro, the new private sector privacy law that's being proposed federally. Our private sector privacy law is a federal law unless a province has enacted their own substantially similar law. So at this time, Quebec, Alberta, and British Columbia have their own statutes, and this new law would apply federally and to the rest of the provinces and territories. Although, of course, there's a question about whether, once it's enacted, those provincial laws would still remain substantially similar. Bill C-11 was tabled in Parliament in November, and it has two parts. It seeks to enact the Consumer Privacy Protection Act, or the CPPA, and also creates a Personal Information and Data Protection Tribunal, which would hear appeals of Privacy Commissioner decisions. And we'll talk more about what that would look like as we go through. It's a really significant and long-awaited piece of legislation. And like many things that we wait for and anticipate for a long time, my personal perspective, the panelists can obviously disagree with me, is that it hasn't entirely been worth the wait, but it does try to do a lot of things. So it reiterates an emphasis on consent to allow collection, use, or disclosure of information, but then it also creates a series of exceptions, and we're going to talk some more about those soon. It includes some nods to new technologies. It creates algorithmic transparency provisions that gives people the right to know when or how predictions or decisions were made about them using artificial intelligence applications. It also addresses the issue of de-identified information. That's information that has had personal identifiers removed to attempt to make it non-personal. And again, that's something else we're going to talk about more fully, so I won't describe it too often. It adds a whistleblowing provision for the first time in our federal privacy law. It adds big changes to the enforcement regime, something that has been called for a long time, and it's worth talking about whether or not they're going to meet the mark and serve the purpose that we were hoping they would. And it creates a new private right of action that allows individuals to sue in cases of privacy violations. It does a bunch of other things as well, but that's enough talking from me. I'm going to turn to our panelists, and I'm going to start very broadly, and we'll see where it takes us. So first of all, Mariette, what aspects of this new law do you think are particularly important, and why?
I must say that Bill C-11 contains rules and limits, often quite weak, I think, concerning the concerning the use of already collected data. Bill C-11 does not address what I still consider one of the most important questions. When and why should the collection of data related to an individual and his or her activities should be allowed? And I think when everybody, a lot of people were expecting Bill C-11 with a lot of anticipation, I must admit that I have been, I must say, fairly disappointed, because this part of the debate about the collection has never been done, and it seems that it will not be done. I have not much more to say for now.
It's interesting because, and I was just, the pause was because I was thinking about that. I hadn't heard a disappointment in the bill framed quite that way. And you're right in that what the law does is talk about sort of guidelines for the use of information without fundamentally dealing with the question of what is and is not an appropriate collection of information in the first place. And I'm curious what our other panelists think about that observation, because I think it's a really interesting one. It would change the scope or the way that privacy law has traditionally worked in Canada. So what do you think, Teresa? What do you think of that?
Yeah, well, you know, I think it's an interesting question about what the parameters are for data collection, and whether things are simply, you know, whether some things are simply inappropriate, whether we should be starting to lay down, you know, guidelines about, or rules about where you know, what you can and can't engage in. There is a provision in PIPEDA, the current bill, the current law, and the same wording is repeated in C-11, which talks about essentially limiting the purposes for collection and use and disclosure to those that a reasonable person would consider appropriate in the circumstances. And that's, you know, that's language that's open to interpretation. Now, we recently saw the commissioners in a joint set of findings on Clearview Ai, I think it was just last week or the week before, talking about that provision and about how the way in which Clearview Ai collected their data was not for a purpose a reasonable person would consider appropriate in the circumstances. You can see an example there where they basically said, you know, quite apart from the other issues around collection, this simply wasn't for purposes that a reasonable person would consider appropriate. Therefore, it breaches the legislation. We still have that same provision in the legislation. So there is a little bit of framing in that regard. But one of the issues that I've talked about before in this context is the human rights-based approach to data protection. And in Canada, for constitutional reasons, I think there has been a real unwillingness on the part of the federal government to get into framing data protection in terms of human rights. They want to limit, you know, it's about privacy protection in the commercial context. And so they don't take a broader human rights frame or set a broader human rights frame to it. And I think that's really unfortunate, because when it comes down to interpreting the legislation and interpreting the kind of language that I just mentioned that sets parameters on purposes, if you don't have that embedded within a frame that is talking about this broader concept of human rights, it can become a very narrow, limited, transactional approach to interpretation. You know, what the reasonable person considers appropriate in the circumstances of this particular online commercial transaction, or, you know, it can shift the way in which this language is interpreted. So I really think that there was a missed opportunity here to really contextualize data protection within this broader understanding of what's at stake from a human and human rights perspective.
David, I want to bring you into the conversation. Sure. So I'm also going to ask you the same question I asked Mariette, which is, what aspects of this new law do you think are particularly important and why? But of course, with your expertise around whistleblowing laws, I'd particularly ask you to focus on the whistleblowing provisions in C-11.
Sure, thank you. And that's why I'm here, because this Act does contain some whistleblower provisions. And many people would look at that and take comfort on it, from it, and think, well, that's good, because then people can speak up if they see abuses of the law and so on, and it can all be sorted out. And unfortunately, I'm here to tell you that that's just not the case. When people call me and identify them as whistleblowers, one of the first things I have to tell them is that Canada is a wasteland for whistleblower protection. We have, as a country, we are among the worst on the planet in terms of failing to protect whistleblowers. The language that's used in these polite circles is deeply flawed, but it's actually much worse than that. We have, at the federal level, I'll start there, a system that's been in place for close to 14 years now, which has consumed tens of millions of dollars of taxpayer money, and which has never protected a single whistleblower. There's a tribunal, as we have in this case, which is supposed to be there to provide a remedy to whistleblowers if they suffer reprisals. And that's really the only kind of protection that they can get. But there's two problems with that. One is that the Integrity Commission in this case acts as a gatekeeper to that tribunal. And so out of the many, many cases that have gone to where people have gone to the commissioner with a concern of reprisal, and the vast majority has refused to let them to go to the tribunal. For the handful of cases, perhaps 7 that have been to the tribunal, until recently, not a single one had even completed the process. And then recently someone did complete the process, the tribunal found against them. And the reason for that is because the way the law is written, the chances of getting a remedy from the tribunal are essentially zero. We've known for 20 years that if you simply send a whistleblower to a tribunal of this sort with the normal balance of probabilities type of standard to meet, they have no hope whatsoever, close to zero. So what is done, this is a little bit technical, but bear with me, is that in virtually every other law you'll find around the world, every other whistleblower law, if there's some kind of connection between the reprisal and the adverse actions taken against the whistleblower, then there's a reverse onus of proof. So now the burden falls on the employer to prove that the things that they did to the whistleblower were not motivated by reprisal against them for blowing the whistle. So that's at the federal level. So what we actually have is a law that hasn't protected anyone in 14 years and does harm, because we have a commissioner claiming to people that they're protected, and people come forward and then their lives are ruined and nothing happens to the wrongdoers. We have in this law pretty much a carbon copy of the same system. We have a commissioner who's a gatekeeper to the tribunal. We have a tribunal, there's no reverse onus. And so the chances of anyone receiving any protection from the system are essentially zero. And it's really, you know, I labor to try and explain to Canadians just how bad our system is, because it's not how we see ourselves and it's not what we expect from our governments. But just to illustrate, there's a study ongoing which will be completed very shortly by one of the leading NGOs in the world, the Government Accountability Project in Washington, DC, and the International Bar Association. And we have access to some of the results of that. They have a 20-point scale for whistleblower protection laws. Most of the countries that we would compare ourselves with, and by the way, there are more than 60 countries now that have or are about to have whistleblower protection laws, national laws. They have looked at all of those, and the countries we would compare ourselves with score in the 16 to 17 to 18 point range. For Canada, it's debatable whether we even get 1 point. We're really at the bottom. The other country that's similar to us is Lebanon, a failed state. So, so that's where we are in whistleblowing in Canada. And anyone who looks at this law and sees those provisions and is comforted by them should immediately revise their opinion and view this really as a trap. It's a trap.
That is an extraordinarily grim assessment.
I'm sorry, that's how it is.
And it, you know, the obvious follow-up question to that is, can it be fixed? What would make it better?
Well, it can fairly easily be fixed, because what's happened in the last 10 years particularly is that all the research that's been done over, you know, now more than 4 decades of learning about whistleblowing, there's now a very strong and well-developed international consensus regarding what best practice looks like. And in fact, the European Union has recently, last year, issued a directive to all its member countries to implement strong whistleblower laws. That they will have to do that by the end of this year. And that directive is actually one of the best sources. You look through that directive, read the preamble, it sets out exactly how to protect whistleblowers effectively. Very few weaknesses in it. So the knowledge is out there as to how to do this. And all it requires is that the politicians turn to their drafters and say, please write a law that complies with international best standards. But that's not happening. And in fact, again, I'll talk about the federal level. 4 years ago, we had the 5-year review of our federal whistleblowing law. It's called the PSDPA. The 5-year review of that took place at the 10-year mark. They just didn't bother to do it for another 5 years. When they got round to doing it, it was given to a committee, the Government Operations Committee, which we found out about this early on in the process. We were able to get ourselves before that committee as witnesses. And they became engaged. They really dug in. They did a fantastic job. They worked in a very non-partisan fashion. And they ended up, after dozens of witnesses and months of work, they produced a unanimous report calling for sweeping recommendations to our current federal law, more 25 recommendations if my memory serves me. And none of those has been implemented. None.
And this doesn't help. I think that puts us in the mood to dive further into other faults and failures of this bill. And I think one of the questions off the top has to be questions around the way that this bill now frames and institutes the concept of consent. So consent has been at the core of Canadian privacy legislation traditionally. Recently, there's been a great deal of discussion in the privacy world, at least in our little bubble, about the reality that the concept is really hard to make work in the age of big data, which relies on more and more information about people for purposes that may or may not be defined at the point of collection. So the question first, and I'm going to start with Mariette to ask her, how do you think the concept of consent is addressed in the CPPA? What do you think about the way that it deals with consent?
Oh, I think it has been very badly addressed. At the time there was discussion and consultation to review the act. One of the main reasons presented mainly by the Privacy Commissioner was that the actual format of consent and the actual rule around consent were outmoded, were not were not correct for our actual digital age. So what Bill C11 offered us is maybe, I'm saying maybe, some changes in the format of the consent and the various obligation to present a different type of consent to user. But it's not my concern. My main concern is It's very nice to say, well, you will have now a different format. You will be able to understand what you consent to. But if you look at the Act, what I'm looking is not the section about the consent, it's the section about the exception to the consent. Teresa has written a very good blog, although I don't agree with your conclusion, Teresa, but your description and your analysis, more than a description, your analysis of the various problems with the consent provision was very good. If I could put that maybe very bluntly, the article concerning the exception to user consent are allowing almost any possible collection of user data. And all of this legally. You don't have to have a lot of legal imagination to look through those. I don't recall how many exceptions there are to that list of exceptions. And you know, when I start working on that, one of the first contract that I looked was the Google for Education contract in 2008. And one of their, the reason why they say they will use your data, it was to improve our services. If you look at the actual exception in Bill C-11, you know, you could take those exceptions and probably legally being able to collect as much as information as you want. And I'm not talking about illegal collecting of information or breach of a system. I'm just talking about, here is a new law, a new proposal, we have a lot of exceptions, so we want to do this. We want to collect this type of data because we think it's important for our organization. Is there any of those exceptions that could help us to collect the data we want to? Believe me, I think you could do almost anything. It doesn't, basically what this law is doing is that we are going from what was a consent-centric type of consent-centric base to an accountability and risk prevention model. Okay, that's the model that is in C-11. I don't agree with that model. But worse than that, if you analyze, and it's not the right time to do that, but if we were to take the time, as Teresa did in what she wrote, and analyze each section and subsection, those exceptions totally destroy the very concept of consent.
Teresa, do you agree? I know you've written extensively on this, and what do you think?
Yeah, unfortunately, I you know, that is that's my sense of it, that these exceptions are so broadly worded that that they can be very easily exploited. And they're not just exceptions to consent, but they're exceptions to knowledge and consent. And I think that's really important as well, which means that there's no requirement to even provide notice that the information is being collected or that it's being used in those particular ways. So there is a transparency problem. Now, I've had, as I'm sure you have had as well over the last, since this bill, you know, was introduced in the House, many conversations with lawyers about these provisions. And one response that I frequently get from lawyers is, oh, don't worry, this exception was meant to deal with this narrow circumstance, right? So, you know, it was meant to deal with that. It wasn't meant to do all these other things that you're saying. Well, that's great. But you can interpret it to do all those other things. And I think that's the problem. It may be an issue of drafting. It may be an issue of just not you know, thinking through or workshopping through all of the possible scenarios. But I think we have a bunch of exceptions which perhaps were pushed by certain industry stakeholders for certain purposes, but were worded in ways that capture a very broad range of other purposes. And they're exceptions to knowledge and consent, with the result, as Mariette has said, that we, you know, we've really taken the stuffing out of the concept of consent, and it becomes very, very seriously undermined. So I think that this is a really important issue. Of course, the other piece that I get is that don't worry, there are guardrails. There's the section that I mentioned before, which is you still can't collect for purposes that a reasonable person would consider inappropriate in the circumstances. And that may be true, but you know, part of the problem is, as we saw with the Clearview Ai situation, is that by the time somebody gets held to account, there's massive amounts of information that have already been collected and already been used and applied in particular ways. And if it's an exception to knowledge and consent, then you've also got people who are struggling to know that this has even taken place so that they can get to the point that they can file a complaint about the practice and get some kind of recourse. So I think that it really, even if you might succeed with a complaint and ultimately be successful on that level, it may be only after the damage is done. So I think leaving these broad, expansive exceptions that can be interpreted in so many different ways to undermine both transparency and consent is an enormous problem. And just because I always get, you know, lawyers who also say, whenever I say this, they say, oh, but there's a separate transparency section that you must have missed. Well, I didn't miss it. I just don't believe in it. There is a section later on in the legislation that says companies have to provide a general description of how they use exceptions to knowledge and consent. Well, a general description, a general account of how they, I'm not persuaded. I'm sorry, that's not, for me, that's not adequate transparency. So I think that this is a really big issue in this legislation. I do think the government was trying to reduce the consent burden and trying to do things, you know, I don't think it was necessarily maliciously intended, but the result is a profound and serious incursion on transparency and on the concept of consent.
We've mentioned the Clearview Ai case a couple of times. So for audience members who haven't heard of it, Clearview Ai is a US tech startup company that sells facial recognition software primarily to law enforcement bodies. They compiled their database on which to run their facial recognition algorithm, she says in English, by scraping the internet and collecting upwards of 3 billion images from sites like professional sites, social media platforms, and the open net. And there a recent investigation, as Teresa referred to, by the Joint Privacy Commissioners federally and of Alberta, Quebec, and BC, found that this essentially was not just illegal, but was in fact an act of mass surveillance. And I think that it's an excellent example that I just wanted to explain the context of, because it really does, it's an incredibly recent case that really highlights the profound risks to individuals of sort of unfettered data collection and allowing businesses to decide for themselves what in fact is a legitimate business purpose. That actually sort of brings me to a question that I wanted to ask David, who, as well as his whistleblowing expertise, is a former management consultant. So I'm very curious to hear what you would think about the provisions in Bill C-11 that essentially allow businesses to develop their own codes of practice and privacy management programs in order to govern their privacy behavior. Is that going to work?
Well, I'm not sure that my business experience, like my management consulting experience, makes me an expert in this, but I would say that, I spent a couple of decades working with all sorts of organizations all around the world. And I have to say that, the corporate machine can be a thing of beauty, with all cylinders firing and serving the customers, becoming more and more efficient and so on. But that generally only happens in an environment where they have to do that in order to survive. In other words, where there is real competition and a rational pressure to meet the needs of the customers. When you don't have that because of a monopoly, or because you're in a sector that there isn't competition, or you're in government, then what tends to happen is the organization turns into an inward-looking bureaucracy in which all the efforts are focused on just meeting the needs and desires of the senior management. The customers are forgotten. The nominal mandate of the organization is forgotten. So very long answer here, I'm sorry. But the bottom line is that corporations do what seems to be in their best interests, and they're very efficient and skilled at doing that. A good business model, like I described at the beginning, is wonderful and serves society tremendously well. But I'd say that a great many businesses and governments, that's not the model. The model is like we see in Facebook or the big tech companies. The model is exploitative and is not in the public interest, and is working against our own interests. So whether they would put in place anything that would of value like you described very much depends on the situation.
Thank you. I think it's both interesting and true, and comes up in a variety of situations around data collection in the private sector. It's important to remember that a private sector organization has a fiduciary duty to its shareholders. And that's a foremost obligation that supersedes obligations around data protection for customers, absent a strong regulatory framework that can hold them to account. So, it's an important question in our conversation about the holes and exemptions and consent that you could drive trucks through. Speak to the problems of leaving too much leeway for businesses to make their own decisions about what is in fact what a reasonable person would expect them to be able to do with information. I think another aspect of the bill that in some ways is an attempt to provide a certain level of protection for consumers is around de-identified information. I want to talk about that a little bit because it's something very new in the bill. De-identified information is basically information, it's basically a process of attempting to remove personal identifiers from information using technical processes to try and make sure that what's left doesn't identify an individual or can't be used, it's not reasonably foreseeable that it could be combined with other information in order to identify an individual. So in other words, it's an attempt to take personally identifiable information and render it non-personal. And there's been a debate for a while about whether once information is de-identified, it is or is not within the scope of privacy law, which protects personal information. So what this new bill does is it actually defines the term to de-identify, and it brings de-identified information sort of into the scope of the law, but in a way that mostly serves to then take it right back out. So I'm interested in your perceptions on, first of all, what you think of the way that de-identified information has been brought into this bill, whether or not it will serve any purpose, whether it will provide benefit for protection of personal information, or whether it brings with it some significant risks. I'll start with Mariette. What do you think?
I think maybe what I would like to say about de-identification is slightly different from the angle you approach it. Yes, one of the main discussion about de-identification is what will be the methodology that you will use to make sure that you cannot relate this data with the user it has been collected from. Let's assume for a moment that the methodology used to identify information collected from Mary Smith is almost perfect, okay, which is probably not, but let's assume it's almost perfect. One question which is important concerning de-identification is, but what happened with the identified data? And the reason why I'm asking that question is that Section 20 of Bill C-11 says when I collect personal information, basically, I need to have consent. Okay, so I have collected information from Mary Smith with her consent. Section 20 says that if I want to de-identify the information I just collected from Mary Smith with her consent, I could do that without any notification to Mary Smith, without any consent from Mary Smith. Section 20. Section 21 says that, and I'm just quoting part of it, says that once I have de-identified information in my end as an organization, I could use it for my internal research and development purpose. So I'm coming back to my first question. What happened with de-identify information? Let's say you have collected information concerning a specific problem related to drug consumption or something like that. So you have collected information about location of the person. You have collected information about her behavior, her family, tons of information. Let's say that all of this has been done with the consent of the person and everything has been explained to her. But after I have completed the project, I have that information, I de-identify the information, and after that, I could use it for my internal research and development purpose, meaning that I could use it to make new product, depending on the type of organization I am. I could use it to make new program, new type of accessibility. So at the end of the day, although the de-identified information that has been used could not be related anymore to Mary Smith, it will have impact on Mary Smith because it will create program, product, or whatever result of that processing under Section 21 that will apply to Mary Smith as a minority group, or rather as a specific group. So when you say, well, you could do whatever you want, basically, with the identified information, I profoundly disagree.
Absolutely. It's so fundamentally important, and I'm glad you brought it, and I'm going to reiterate it because it's so important that using information about and from individuals, even if you don't know who they are, can be used in ways that have consequential impacts on their life and their life chances. And we don't have those conversations enough. We assume that if it's not individually identifiable, it doesn't cause harm. And that doesn't pay attention to sort of the collective impacts of the use of data and the way that things like social sorting affect individuals. Another aspect of the de-identified information in the bill is around some exceptions for use of information for socially beneficial purposes. This is a phrase that you can probably tell by the way I say it, drives me insane. I've got deep problems with it. I'm wondering, Teresa, if you could talk a little bit about what we're talking about when we talk about socially beneficial purposes and how they are laid out in the Act in relation to de-identified information.
Yeah, and so the socially beneficial purposes exception is another one in the list of exceptions to knowledge and consent. And Mariette was talking about some of the other de-identification exceptions, which are also part of this big package of exceptions to knowledge and consent. So it's part of that. Now, I think that what the government was trying to do with their socially beneficial purposes exception was to create space to enable the use of de-identified information for socially beneficial purposes. And I'll come back to the definition of that in a second. And I think that they were thinking probably of the Sidewalk Toronto context and all of the discussions around data trusts and how you could take de-identified information about, for example, the members of the citizens of a city and use it to develop resources or knowledge that would be useful and beneficial to that population and create some kind of context for this that didn't run into problems with data protection laws. So I think that was their objective. But it's like some of these other exceptions, maybe there was the objective, but I don't think they tested it very hard or tried to figure out what all the difficulties and problems with it are. And there are many with the socially beneficial purposes exception, as far as I'm concerned. One of them, of course, is the definition of socially beneficial purposes. So they do so many things with this exception. First, they describe the kinds of uses of data in a way that I think actually preclude some benign uses of data that are made. So it's not just the data, the de-identified data themselves, but data derived from that data. So visualizations or charts, right? And so all of a sudden, this is constrained and has to fall within the terms of the exception. If it falls outside, then you can't do it. And that seems odd and unnecessary. At the same time, it talks about socially beneficial data and identifies particular actors who qualify for the socially beneficial data exception. And if you're not one of those actors, then you fall outside it. And I saw a piece written, I think it came out today by Chantal Bernier that was complaining about this unduly narrow scope of it, by picking certain types of actors and certain types of purposes. Again, certain purposes are identified as socially beneficial, but there may be many other purposes that are socially beneficial that fall outside the narrow parameters that are constructed. So kind of any way you look at it, the provision is problematic and is over-inclusive or under-inclusive or doesn't quite hit the right thing. And then I think overall, another one of the really major problems with this is it creates this exception to knowledge and consent for socially beneficial purposes, and allowing all of the sharing of this de-identified personal information, but doesn't set any guardrails or require any guardrails to be set around the control or the use of that information. And so when we talked about data trust in the context of the Sidewalk Toronto development, the concept wasn't just to have a body that you could send all this data to that would then use these data for good purposes, but it was to have a body that actually would have a mandate that set out what those what it could and couldn't do with the data, what the parameters were, what people were in agreement on, that would have some kind of representation that would take into account the community voice, the voice of the individuals, and that would use contractual licenses or other mechanisms to prevent those who access the data to use the data from doing anything other than what they were allowed to do with the data. And there's nothing that provides for any guardrails or requires these kinds of guardrails. So it's a nice idea. It's one of those things where you have this great idea and you blurt it out, you throw it out, and everybody says, yeah, that's a great idea. But of course, there are all these problems with it. And I think that's what's happened. Somebody blurted this into the legislation and there it is. It's full of problems. And I think it's extremely concerning.
David, you're nodding. Do you have a...
Oh yeah, no, I was just agreeing furiously. But I wanted to just I throw in another thought here, and that is that, any discussion about privacy and invasion of privacy, we have to talk about Edward Snowden. Here's someone who exposed that not this corporation, but the state was illegally carrying out mass surveillance of virtually all the US citizens, and had been doing this for years. And the reason that he is where he is now in Russia is because he had looked at what happened to other people who attempted to blow the whistle on abuses within the intelligence community. And they had been very, very harshly treated. They had been prosecuted under a 100-year-old Espionage Act that gives them no public interest just defense. So he had to go to Hong Kong to get the information out. He had to get completely beyond the clutches of the US authorities. And of course, now he's exiled in Russia. So I think it just illustrates, number one, how important whistleblowers are. That was arguably the most important disclosure ever related to privacy, and how difficult it is to protect whistleblowers and how important these people are. And frankly, in Canada, we have no track record of even trying to protect whistleblowers. So, we really need to up our game. And and it's so important because in all the types of abuses that you're talking about, There are ordinary people in both organizations seeing what's going on, who can blow the whistle. They have the knowledge, they know what's going on, they see that it's wrong, but without proper protection, they're taking terrible risks by coming forward. They're going to lose their careers, their livelihood, their lives are going to be blown apart. So again, the importance of writing some proper protections for these people in order to make the law work.
So no appropriate safeguards or guidelines or guardrails around socially beneficial purposes, including the socially beneficial purpose of whistleblowing in the case of, wrongs that need to be righted, but can only do so when the light of day shines on them. For the audience, we're getting very close to the time that we're going to turn and answer your questions. So I'd encourage you, if you haven't already started, to be popping your questions into the Q&A panel to do so now. As we move towards that, I'll ask maybe one more question of the panelists to give you some time to get those questions in. I think one of the stated purposes of creating a new privacy law was to modernize the law in the face of the ever-changing and evolving new technologies. That's one of the foremost reasons that's been put forward for the need to have new privacy laws in Canada created at a time not when to open a file meant to click on a computer, but to open a file meant to pull open a drawer. So the question is this act fit for that purpose? Does this act contain provisions that will allow it to do a better job of mitigating some of the risks of information practices that we know are prevalent in the data age? We've skirted around this in a bunch of different answers already, but I'd like to ask it directly, and I'm for Mariette, because I know that you've done a lot of work on data brokers, which is a particular manifestation of an information age practice. If you could tell us what data brokers do, how they fit into the information ecology, and then what is your assessment of whether or not the new law is going to do a better job than the old one at protecting people from the risks of that data brokerage practice?
Data broker, if I could quickly define it, are usually very discreet organization. They don't go in the public place. They are usually large organization, and mainly their work is to collect data from multiple sources, publicly available or other sources that they could qualify as publicly available, and to organize that data with they are huge organization. They hire very competent professional person, and they organize that data according to the requests of their clients, because that's how they make a profit. They have client, it could be insurance company, it could be other type of organization who do want to know what could be their next product, or who are their audiences or clientele, and how they could reduce their risk, or how they could change their product. So they will ask a data broker to collect information from them, but much more than collect information, to analyze that type of information in an extremely sophisticated way. I would suggest that you could take the name of I don't want to name any of them here, but you could take the name of any large data broker and go on their website and see what are the product offer, what type of analysis, study, call it as you want, they could do. Now, will the Bill C-11 protect the user from that type of collection? Well, most users do not even know, not necessarily, they know maybe about the existence of data broker, but they don't know exactly how they work. I don't either. They don't know exactly how they work. So how could user X Canadian citizen under Section C11 will decide to file a complaint to the Privacy Commissioner because he or she thinks that her data has been collected without consent by a data broker. Even saying that sounds very extremely naive, okay? So if I were a big data broker, let's put it this way, I will not worry a lot about C11.
We're perpetually optimistic on this panel this evening. The other technology that's rapidly coming to the fore, where Canada has aspirations to be a global leader, is artificial intelligence. So Teresa, I wonder if you could comment briefly on your assessment of C11 and its capacity to protect Canadians in relation to the use of their information in artificial intelligence applications.
Yeah, so there is a right to an explanation, I guess that's what it's now being called, this idea of the right to an explanation when it comes to automated decision making. And one of the interesting things about the provision in Bill C11 is that it goes beyond the right to an explanation regarding a decision that is made using artificial intelligence, but it's a right to an explanation of a prediction or a recommendation or a decision. So in that sense, it seems to be broader. And it's an explanation of the decision as well as how the personal information that was used to make the prediction, recommendation, or decision was obtained. So how did the company get that information that fed into that? And so that's interesting. How it will work, what it will look like in practice, it's not entirely clear, but it certainly seems to be fairly broad in scope in terms of this this right to an explanation of automated decision making. So it's interesting to see provisions like this in the bill, and there are other new provisions that that have been introduced around the right to disposal of data, or the right of erasure, and the right of data mobility, and so on, that are meant to kind of address this next generation of rights. And they're all rights that are meant to enhance user control over their personal information, and to make more, certainly in the case of a right to an explanation, make more transparent automated decision-making systems. So it'll be interesting to see how that plays out, and it'll be interesting to see how that fares in debates and about C11 in Parliament as well.
Thank you. I've got more questions, but I think the time has come to see if the audience has burning issues that they'd like to address with the panel. Ange, could you help us out with the questions?
Yeah, hi Brenda. The first question is from Angela, and Angela asks, can anyone on the panel speak to whether C11 speaks to where electronic data is housed? Is there currently, or in C11, a requirement to house personal data of Canadians in Canada? And does it make a difference if data are stored in Canada?
I'm happy to jump in on that if you like.
Please.
Yeah, so data localization is a really interesting issue, and it's one that is getting a lot of attention, both in terms of data protection laws, but also in terms of international trade treaties, because of course data localization requirements limit the flow of data across borders, and so they're not terribly popular in terms of international trade treaties. So one thing to think about and to keep in mind is that as the negotiations for bi and multilateral trade treaties continue, things like the Canada-US-Mexico agreement and the Trans-Pacific Partnership Agreement progress, we're starting to see provisions that place limits on the ability of government to require data, to impose data localization requirements that would interfere with the free flow of data, although there are some exceptions. But data localization sounds like a great idea for privacy, the idea that you keep personal data, particularly sensitive personal data about Canadians in Canada, primarily so that it isn't subject to legislation like the USA Patriot Act, where another foreign government has pretty free pretty much a free run in terms of trawling through the data if they so desire, right? So that's the privacy justification for data localization. But data localization also is complicated because some governments are looking at data localization because they want to be sure that they can have ready access to that data for law enforcement and national security purposes. That if the data is housed, for example, in a cloud services that are located offshore, that it may be much more difficult for Canadian law enforcement or national security officials to get access to that data. So data localization is also sometimes considered as an option in order to increase the ability of local authorities to gain access to that data, which has privacy implications. And then the other privacy dimension of data localization requirements is cybersecurity and security of that data. And if there isn't sufficient capacity for localized data storage, and by sufficient capacity, it means sophisticated enough to have the appropriate up-to-date cybersecurity measures in place, then your data may be at much greater risk. And so some argue that, it's the big cloud service providers that have the better security protection for that data. So data localization is a really complicated issue, but to go back and make a short answer to your question, there's nothing in Bill C-11 that requires data localization, but it remains an interesting issue and one that's the matter of a lot of debate and discussion.
Do any of the other panelists want to weigh in on that one before we ask for the next question? I think not. Ange, what's next?
Yeah, the next one is from Martine. Martine says, I understand that de-identification is to remove identifiers that are personal attributes that can be used to help identify an individual, such as names, social insurance numbers, passport numbers, and health card numbers. But isn't there an equal problem with indirect identifiers, personal attributes that are not unique to a specific individual on their own? Examples include height, race, hair color, and more. But indirect identifiers can often be used in combination to single out an individual's records. Carnegie Mellon University's Latanya Sweeney showed that 87% of the US population could be uniquely identified using only 3 indirect identifiers: gender, 5-digit zip code, and birth date. Does the proposed Canadian law deal effectively with protecting our identity from commercial interests which buy data from data brokers? If not, what should be done?
I think we've lost Mariette. Hopefully she will, or at least she's vanished from my screen. Hopefully I'm just flagging that for our tech team so that if she's trying to get back in, she can be let back in. Do either of you want to field that, or?
I can jump in. Yeah. So yeah, and this has been one of the challenges with de-identification, this idea that in fact it's very difficult to completely de-identify data, to anonymize it such that it is not capable of re-identification. So when I was talking about the use of de-identified data for socially beneficial purposes, for example, and I mentioned that there weren't sufficient guardrails, some of those guardrails would be contractual agreements not to use the data in ways that might lead to the re-identification of individuals. The legislation does contain a penalty for re-identifying de-identified data. So it does, contemplate that this would be something that is not permitted under the legislation, attempts to re-identify individuals. But it is absolutely always a risk, and with the more data we have and the more processing capacity we have, the easier it is to re-identify data, individuals within sets of de-identified data.
I think it's interesting that, often one of the pieces of legislation that this bill is inevitably going to be compared to is the European General Data Protection Regulation, or the GDPR. And in the GDPR, they're much more granular about breaking down methods of removing personal information. So everything from anonymization, which is supposed to be the information cannot be re-identified, to de-identified where there's always a risk, to pseudonymized information, where they remove personally identifiable information, but where the information can potentially be linked back together under certain circumstances, in certain certain conditions and with certain guardrails put around it. Unlike that, C11 talks about de-identified information only. And there's probably a missed opportunity there to be more granular about the different kinds of ways in which information can be manipulated and the different purposes that it can be put. I know that I've spoken to a range of people who are more technically inclined, who basically say this is a definition of de-identification that is already out of date. And when you're talking about the process as opposed to the purposes for the actions, you're already not dealing with the right thing. So I think that it's not just the case that there are issues with de-identification in terms of the potential for re-identification, but also there are issues with only looking at de-identification as a method for masking identity. What's the next question, Ange?
Hi, yeah, the next one is from Victoria. Victoria asks, knowing the lack of privacy Bill C11 protects in terms of corporate commercial interest, what advice do you have for individuals wanting to protect their online privacy and information? Are there any preventative measures individuals can take or loopholes around the Bill C11 legislation that may account for greater privacy?
Welcome back, Mariette. Do you want to jump in on this one?
Well, one thing that we could say is information that is not provided could not be collected. I know it sounds simplistic to say that, but it's because there's so much publicity, and also because of the business model of a lot of the big organizations that collect information is based on engagement. The more you use those type of application, the more you want to use it. So I would say that in order to protect you is maybe to go back to the very, very first question I was asking at the beginning is when and why should information be collected? And maybe ask yourself this question is, when and why should I use an application that's basically collect my information? Now, once I've said that,
oh dear. Oops. I think we're frozen.
Oh, too bad.
Oh dear. I think Mariette seems to be having connection difficulties. But I think she's hit an important point here with the idea that data minimization, which is a core privacy principle, the idea that you only collect what you need and you don't collect anything else, is a principle that's been slipping in part because of the rise of AI and algorithmic analysis, big data analytics, which relies on huge pools of data in order to detect interesting patterns. In research I did quite a while back now on connected cars, we talked to industry representatives who said, well, we basically just know that we want everything, because even if I don't know what I want to do with it today, in 6 months, I'm probably going to figure that out. And so if I haven't collected it, I'm not going to be able to do that thing that's going to occur to me, this brilliant idea that I'm going to have sometime soon. So the principle of data minimization fights against that sort of urge, and it's a principle that I think would be helpful to think about more. In terms of just individual actions, and that's a question I get all the time, I think it's in some ways comes down to, and I hate to put the onus on individuals because I think there's corporate responsibility here predominantly. But as an individual, one of the things you can do is be informed, pay attention. We all increasingly just, download the thing, click yes to make it go more quickly, and move on the assumption that if we want it, we're going to say yes. And so we may as well just get on with it. Once a month, instead of just clicking yes, spend the 30 seconds it takes to read the list of things that that application is telling you they want. And if it's a game and you're going to pop bubbles and it wants like your access to your contact list or your camera, it's reasonable to say why, and then to click no and go back online and choose one of the other 500 bubble popping games that doesn't ask for those things that are clearly not related to the purpose of the application. What do we have next, Ange?
Yeah, in following that question, and is from Laura, and Laura asked what precautions can regular people take to protect themselves from data theft online? Is anything safe to share? Are there any resources we can access to learn more about how to protect ourselves?
I can just jump in and say the federal and provincial privacy commissioners do provide a lot of public-facing resources that are meant to help individuals and guide individuals in terms of, explaining certain technologies, explaining certain collection practices, making recommendations for how to interact with certain services and so on. So there is quite a lot of very helpful public-facing information on the websites of both provincial and federal privacy commissioners.
Mariette, we lost you last time.
Yes, I'm mostly sorry for that. It's a kind of vanishing act. One thing that I would like to add is it's one thing, and I agree with you, Teresa, that there are some tools to protect yourself, but it's a little bit a David and Goliath fight. Yeah. You try to protect yourself against collection of information, which is basically at the heart of business model of several organizations. So yes, it's one thing to say I should not, tell all my private life on a Facebook account. It's another thing to say, well, I used to use that public services, and when I enter the building, my information is collected as it has been collected by Clearview. So yes, it's one thing to try to protect yourself, but protect yourself against organizations that are actually perfectly working legally. I'm not talking about Cambridge Analytica or the problem with certain bank. I'm just talking about certain organizations that collect information in a perfectly legal way and will certainly continue to do it if Bill C-11 is enacted.
Which I think would bring to the point that I always like to make, and it's particularly important when we're talking about a bill that's on the table, literally, which is that another thing you can do is to act politically. So if you are concerned that your privacy is inadequately protected and this new law doesn't do it, tell your political representative that. Fire off an email, pick up the phone. There's a Privacy Act consultation on right now where you don't even have to think about the questions that you want to raise. You can go online and answer the ones that they've provided for you. And it's another way of making sure that the concerns that you have about this law or about the ways that your information is increasingly being picked up and used, if you don't like that, to have a say and attempt to influence the political process. Because in the end, as Mariette points out, there are business practices that want your information. And the best safeguard for that is a strong and effective regulatory regime that does place some safeguards and limits around how that can happen. I think we've got time for a couple more, Ange.
Yes, the next one is from Theodora, and Theodora would like to know what stage the bill is at.
As far as I know, the last time I checked, which wasn't today, I'm sorry, it was waiting for second reading. So they had started the debate that would lead to the conclusion of the second reading of the bill, but not finished it before Parliament closed in December. It reopened, and as far as I know, it hasn't reemerged yet on the parliamentary agenda. So at the point that there's second reading, then it will be referred to committee. We've been told that it will go to the ETHI committee, which is the committee that deals with privacy access and ethics issues. And there will ideally be a reasonable public consultation prior to it going back for third reading. So we're at the stage where it's almost but not quite yet ready to be sent to committee for study. If one of the other panelists knows better than that, jump in. Okie doke.
Okay, the next question is, why does Canada refuse to accept best practices with regard to whistleblower protection?
Oh, wow. Well, it's a great question because we're so out of line with the rest of the world on this. We really are the back of the bus, the bottom of the heap. And, you know, I've thought about this a lot. And my general answer is this, that there are really only two reasons that I personally can see why political leaders would not adopt whistleblower protection as a vital tool to protect them, because it's one of the most important ways for the leadership to find out about problems so that they can deal with them before they spiral out of control and become huge scandals. By taking reprisals against whistleblowers, you just make sure that leadership are kept in the dark, the problems go on, and then you're also driving people to the media because they see no other way of getting the problem fixed. So the case for whistleblowing is so strong that I really only see two reasons why leaders wouldn't engage with it. One is lack of knowledge, that they haven't done their homework to understand how valuable this is to them. And the other is lack of integrity, that they believe that their own operations will not stand up to this type of scrutiny. Perhaps their business model or the way their political system works has abuses in it that they fear to be exposed. So I'm not saying there couldn't be other reasons, but those are the main reasons that I see, in my opinion.
Thank you, Ange.
Yeah, the next question, what do you think about the idea of a data bill of rights?
Who wants to jump on that one, panel?
Well, I mean, I could jump in. I mean, that's an interesting question. In my view, I think that this particular bill, this data protection law that we have, Bill C-11, should incorporate within it acknowledgement of the human rights basis for data protection, that there is this, you know, broader set of values that are implicated by the collection, use, and disclosure of data, and that we need to take all of these into account when we're setting the parameters for the collection, use, and disclosure. And that would be a form of a data bill of rights. There are other issues that arise with respect to data, and some of which go beyond data protection legislation. So there may be issues around, for example, content moderation on Facebook and other things that people might consider part of, say, a broader digital bill of rights and broader concept, and whether we need you know, and there are certainly issues with respect to AI that go beyond simply the use of data and that extend to the way in which, you know, algorithms operate and bias and discrimination. So there may be other issues as well. So I guess the question is, you know, do we want to start by adding human rights-based protection to bills, to legislation by like Bill C-11, and then once we've done that, do we need to also address, from a human rights-based perspective, other forms of digital human rights, essentially?
Mariette or David, do you have anything to add to that?
No, thank you.
I think not. I guess, I mean, the only thing I would say, it would really depend, I mean, having one, something, you know, sweeping that deals not just with the privacy implications of the way that data is used, but recognizing that, you know, privacy is essentially a threshold right for some of our other rights. You know, as Teresa mentioned at the beginning, our rights to freedom of expression are chilled potentially if we're subject to data surveillance or other kinds of surveillance that are facilitated by data. Our rights to freely associate with others, and particularly to engage in dissent or protest, can be chilled. So a data bill of rights that sort of took into account all of the different rights that are impacted increasingly by the ever-changing and evolving uses of data in society would be interesting. But then the question becomes, what impact does it have? Does it have some kind of force? Does it have teeth? How does it interact with the existing statutes that we have? So it's one of those ideas that is intuitively appealing that I think would get very complicated very quickly if we attempted to institute it. All right, I think we are at 5:25. Do we have time for one more question, Ange?
Yeah, we can have one more. The next question is, do you think privacy was the main issue why Sidewalk Labs in Toronto didn't move forward?
I can't help it. I have to start with this one. The background to my eagerness to answer this is the Canadian Civil Liberties Association actually initiated legal action, in part because we believed that the potential for privacy invasion in the smart city plan was so grave and so problematic. And also that a vendor was being trusted with essentially developing policy in the absence of an appropriate legal framework in Canada that would give the right safeguards, put the right safeguards in place to make sure that their concept of a smart city didn't become a surveillance city. Privacy got a lot of airtime in those conversations. Of course, the official reason for Sidewalks packing their bags and leaving was COVID and the changing economy. But I do think it's reasonable to say that Sidewalk Labs was not prepared for the grassroots movement that really rose up in Toronto with privacy concerns as one of, although not the only core concern, and that the conversations, the really important conversations that got started during that project are foundational were really important and perhaps actually even fed into some of the ways in which this new law is written, not necessarily to our benefit, but you see those conversations reflected in this legislation. So it was a very consequential project for Canada.
Yeah, I completely agree with that. I think that those conversations were, whether or not it was a deciding factor in any way, the experience was a good one for I think for Canada to really be confronted with some of these issues, to have to think about them, there was a lot of generation of a lot of ideas, a lot of new thinking, a lot of people got involved, and there were some big public discussions about important issues about how we want to live in cities and how we want how we understand public space and our relationship to public space. So these were all really important conversations. And, and Brenda's absolutely right. I think we see the traces of this in Bill C-11. So it shows that, these were important conversations for government. They were listening. They may not have drafted the provisions the way we would have liked to have seen them drafted, but it has had an impact. And so, I think overall that was an important moment for debate and discussion about it was kind of a lightning rod for many, for things, for discussion about things that happen all the time in other cities and other contexts, and they just pass us by and we don't notice them. And I think that's what was so important about it. I mean, our cities have been adopting all kinds of technology that collects data in a whole variety of different contexts and processes it and uses it in different ways. But these are all incremental and slow, and we don't have a big conversation about it. And this allowed us to have a big conversation about smart cities and data and our lives in public space.
We have about 1 minute. I'm sure Jim is going to want to pop in with a closing, but I'd like to give our panelists a chance to give us one final sentence. What is the one thing about this bill that we must fix if we're going to have rights respecting privacy law in Canada? David.
Well, I'll say one sentence. It's excellent that there is whistleblower protection considered in this act, because research shows that is the single most effective way of uncovering abuses. It's a tragedy that what's there is really worse than ineffective. It's a trap.
Teresa, since we seem to once again regrettably have lost Mariette.
Thank you. You know, if there's one thing I would say consent, but we didn't talk about enforcement in any great detail. And I think there's a lot to think about in terms of enforcement, because of course the provisions you have to protect privacy are only as good as the mechanisms you have for enforcing those rights. And I think there's some really interesting, important things to be talking about in that regard as well.
Thank you. Thank you everyone for joining us this evening. I think that, as Teresa pointed out in her closing statement, even though we covered a lot of ground, there was far more that could be covered. This is a big bill, it's complicated, and it's really important. So thank you so much for joining us this evening for the conversation. If you're interested in finding additional resources, I strongly recommend Teresa Scassa's blog. She's done a series of pieces on different aspects of the bill. My own organization, the Canadian Civil Liberties Association, has a range of materials and we'll be producing more. So checking out our website at ccla.org is also an option. And of course, Mariette has done a range of work across topics, including really penetrating work on data brokerages, which we touched on, that you may want to look at as well. Jim?
Well, thank you. And I want to thank you, Brenda, for a fine job moderating for the panel in bringing up so many important aspects of how our government is trying to deal with laws regarding privacy in the digital age. Obviously, a lot more needs to be done. I want to thank you in the audience as well for attending this and for your questions. I think that a lot of important questions were asked. A recording of this session will be posted on the Center for Free Expression's website tomorrow or Friday. The website is cfe.ryerson.ca. And as well, we'll post with the podcast of this event a link to resources that you could read to get more information, including Teresa's blog, the CCLA material, and other materials. So you'll be able to go to that one space to find additional information if you want to look into it a little further. Our next event is next week on Thursday afternoon, February 18th at 4 p.m. And it's on a very different subject. It's titled Canadian Authors and Books and Endangered Species. You know, as although there are many Canadian writers and genuine public interest, why is there a decline in sales and borrowing of Canadian books? What does this mean for Canada? And what can be done? We're going to have a very interesting panel made up of a Canadian publisher, a Canadian bookseller, a leading Indigenous Canadian author, and we're going to be exploring why this is happening and what does it mean. Anyways, if you're interested, the information is on our website about that event, and we have weekly events for the next while, as well as all our previous events. It's cfe.ryerson.ca. And thank you very much for coming tonight. Good night.